Hey guys, Toby Mathis here, and today we're going to go over 7 disadvantages of putting your home into a living trust. Now, you guys have been listening to me for quite some time. You know that I really like living trusts, and I say that everybody really should have them because there's so many aspects of a living trust that are absolutely critical, like the power of attorneys for healthcare, for financial, HIPAA releases, and then making sure that you skip probate. But let's talk about some of the disadvantages that come along too. And I want to be really fair, so I'm going to do some pros and cons, but let's start with the cons. Number 1, and this is an obvious one for anybody who sets these things up. We're just going to go over here and do cons, make a little line here. The first one is the cost of setting it up. So living trusts aren't free. There is time and paperwork, so there's expense in paperwork. Not super simple just to go ahead and clap your finger and it's done, but there's cost involved in actually setting up a trust, and then you actually have to transfer the actual home into that. So there's expense and some paperwork when you start. Now, if your house is actually a living trust, then you might have some issues when you refinance. So whenever you're doing refinancing, you probably should take the property out of the trust first. Like, there are banks that'll refinance inside of a trust, but you're going to add a little bit of complexity that you might want to just ignore by just take the property back out of the trust, refi it, put it back in. They'll oftentimes do that at the closing table for you, by the way, when you're doing when you're actually sitting with the title company. So there is a little more paperwork when you're using a living trust, just to be straight up. But at the end of the day, if you don't, it goes with you, which means it's probated. And if you have multiple properties all over the place, then you could be probating in multiple states. Number 3, and this is one, just to be clear, there's no asset protection. Not while you're alive. So living trusts are a grantor trust. They're revocable, and they provide no real asset protection benefit while you're living. When you're passed away, then there's credit shelter provisions that can be very strong. But while you're alive, not so much. So it's not something that you're putting in place by itself. Hey, I put it in a living trust, therefore my creditors can't get it. No, it's the same as it being in your name when you put it in that living trust. There are things you could do with your home to protect it, but this is not one of them. All right, number 4, and this is a sometimes deal. You're going to have a little bit of hassle with your property taxes. If the county knows it's a living trust, you shouldn't have any issue. There's no place that we deal with where there's reassessments anymore. But you're going to have to provide them with a certificate of trust, or they're going to have to understand that it's a living trust when you do it. You may get some pushback. So I just want to be clear with you. There's a value in doing this. Every now and again, somebody doesn't know what it is, and when they don't know, then sometimes they act negatively and they go, oh, you're transferring it into something or transferring it to somebody else. If they know it's just a living trust, they're very common now. When I first started doing this 27 years ago, not everybody knew what living trusts were, and it was much more difficult. Now, pretty much everybody knows what a living trust is, and they go, oh, okay, yeah, there's no reassessment on property taxes. Here's another one, and this is just to make sure that we're clear: no estate tax benefit. I don't want to mislead you guys. There's no estate tax benefit when you're using a living trust. Now, sometimes it comes in when there's no portability in the code, which there is right now, where then the trust, yes, it could have an estate tax benefit, but as we are standing here right now, there's no real estate tax benefit that comes along. It does not avoid anything that has to do with estate taxes. So I don't want you to think that hey, I did a living trust, and therefore, if your estate is large, you got a $20 million estate, which isn't going to be a big issue if you passed away now. Might be if the Tax Cut and Jobs Act expires and they allow those provisions to sunset and the estate tax reverts in a couple years to, $7 million. All of a sudden you may have a tax issue. I don't want to mislead you. Living trust is not what the planning. That's not the planning that's going to help you there. You got to do another level. Number 6, as far as a disadvantage or a con, would be the potential loss of a homestead. Now, I'm just going to write down homestead, because nowadays, never an issue. But if you transfer it into trust, if it's obviously your living trust, nobody's going to have an issue. It doesn't do anything with your homestead exclusion. If you're transferring it into a trust and you change the name or something, you may have somebody push back a little bit. Generally speaking, as of this point, nowhere am I aware of where it's going to hurt your homestead. But it's something you want to be aware of, that pops up from time to time, and states can do what they want sometimes. Now, there's no reason why it doesn't give you asset protection. There's no reason why it should cost you your homestead. But in the abundance of caution, I'm just going to raise it as an issue so that you're not surprised if a county says, oh, what about you transferred it, you lost your homestead. And it's like, no, you didn't lose your homestead. They don't understand that it's a living trust. Sometimes they think, oh, you transferred it to somebody else. Not the same thing. All right, and 7, the last disadvantage of transferring your house into a living trust is living trusts, sometimes there's complexity in amendment. So if you're going to change things, I'm just going to put amendments. They have to be in writing, for example. There's always going to be an element of a formality if you're going to change the trust. If you're going to make changes or restatement, you can do it at will. Because a living trust is a grantor trust, it's fully revocable, you can change it whenever you want, but you want to make sure that you're documenting those changes. And so just, again, exercise of abundance of caution. I'm just trying to give you every disadvantage I can think of. It's slight, and it's way easier, by the way, than if you did a codicil on a will, but I don't want to mislead you. It's still an amendment. You got to make sure you sign it. You have somebody else, possibly, depending on your state, you might have to have it witnessed. Sometimes it makes sense to have it notarized just to make sure that you never have an issue of it creeping up in the future and somebody saying, oh, they didn't do the amendment right. No, I want to make sure that you're dotting your I's and crossing your T's. Of course, if you're working with Anderson, it's easy. We take care of all that stuff for you. We have these never-ending, these kind of our forever trusts. The unlimited living trust is what we call it, where we do amendments every year. It's all included in the initial price, so there's no cost to it. But some places they may charge you on that amendment. All right, what are the advantages? So let's just say pros. Why are we using these living trusts? What are the big ones? And the biggest one, obviously, for most people is you avoid probate. Many states have statutes that allow a certain amount of cost to be automatically given to lawyers and to personal representatives if you go through probate. So we don't want to go through probate if we can avoid it. We want to avoid probate. On average, the cost, depending on who you look at, some of the larger bar associations look at it being, on average 3 to 8%. When you talk to ARP, they did a mid-level, mid-size estates, and they found it to be as high as 20%. Whatever that number is, it depends on your state and how complex probate is. You could avoid it with your living trust. That's why they're they're so powerful. And it keeps you from having to go through a long process to distribute assets. For example, many states, they will not transfer real estate for a minimum of 6 months. They'll tie it up. So you can't do anything. You're going to be stuck, or you end up having to petition the court to enter into transactions. And if you're in a market like we had in 2008, or if we're in a run-up market, or if there's something going on with that property, or if there's any sort of financial difficulties, that could prove like very, very disruptive to you. So what are the pros? The pros, it avoids probate, which means less expensive and faster distributions. Number 2, privacy. So a probate is a public record. So if you have a property that goes through probate, or an estate that goes through probate, you're disclosing everything about that estate. Anybody can go look it up. Anybody can go in and see. So when you use a living trust and it avoids probate, it's a private matter. You and your trustee are handling it, or you're passed away, but your trustee and your beneficiaries are handling it. It's not a public record. Somebody cannot go up and say, oh, what do they have? And there are cases where we've had burglary rings targeting probates, where they would find out out of state beneficiaries, here's what's in the house. You're giving them a shopping list. Unfortunately, that's happened where people would actually look at it. There's still groups also that target marketing by going out and getting probate records. If you've ever dealt with real estate investors, you know that sometimes they target the probates, especially if there's out-of-state kids and they're trying to get a good deal on the real estate by saying, hey, I'll buy it, pennies on the dollar, so you don't have to deal with the whole probate and everything else. they're doing it is taking advantage of the situation. Some people might say, oh, they're doing a service. They just saved you having to go through all that pain. You know, it's tough. But I like the privacy. Flexibility, control during your lifetime. Easy to change, easy to alter, and then probably the most important factor. If something happens to you during your lifetime, your living trust actually kicks in. It's not effective when you die. Like a will, you probate it. Will doesn't do anything while you're alive. Living trust absolutely gives somebody the ability to step in and handle your estate, your trustee, your successor trustee. If you're incapacitated or otherwise unable to handle your estate, you could have somebody step in and still give you, and still make sure that your wishes are being maintained. And basically, I would term it this way. You basically have lifetime management. While you're able to, it's you. When you're not able to, you have somebody else. Then when you pass away, you could have that same person or perhaps somebody else come in and manage the estate after that point. So it has during your lifetime, you could have a successor trustee, maybe it's one of your kids or whatnot, and you could still say, hey, when I pass though, I want to make sure it's, a non-interested party. Maybe it's a bank, maybe it's attorney, CPA, maybe it's your uncle, somebody who's not a beneficiary looking at it. And that and that takes that's a huge advantage. And I'm going to put that up there as well. And that is during incapacitation. That there's ease of your estate during incapacitation. So we don't have to go through the state and start guardianship proceedings or a conservatorship. You have it already covered inside the documents. In fact, in our trust and almost all trusts that I see, there's documents for financial power of attorneys that it's not just the trust itself, but there's also ancillary documents. There's documents for healthcare. So there's already things in place to allow somebody to step in and avoid having to go to a state court proceeding or have to go through that. It makes it very much easier. And then I'm going to say reduce risk is number 5. And when I say risk, I'm not thinking typical lawsuits. What I'm thinking of is avoiding risk of having your family just contest and eat itself in the wake of your passing. So a typical situation kind of goes like this. Let's say there's 3 kids. Dad predeceases mom on average. Mom or whoever is the surviving parent, one child sometimes goes and takes care of that parent. Quite often, they'll either bring the parent and have them live with them, or they'll go move, or they'll live really near, close to parent. And they're the one caretaking for that parent. And that parent oftentimes says, I understand the sacrifices this child does, so they give them a little something extra. Maybe they give them 40% of the estate and the other 2 kids each get 30. That's a recipe for a contest action. What happens is the kids that survive, or the kids that did not help mom or dad, that were not there at the end, let's say there's 5 years of in-home care before mom passed, the kids that weren't there, that weren't helping, not only is there a kind of a humiliation, not only is there feeling perhaps a little bit of jealousy, maybe they feel bad about themselves, and it causes them to react in weird ways. They'll oftentimes say undue influence or bring a claim against the child that did step into this. And by the way, this has happened in my wife's family, and it just destroys the relationships as a result. Somebody staying and helping grandma, before grandma passes, grandma tries to do the nice thing, and everybody attacks that sibling. I've actually had a client where the siblings literally took care of mom the last 10 years, and they booted him out of the house. As soon as mom's passed, one of the first things they tried to do is get him out of the house because he was living in mom's house. You can't live in mom's house anymore. We're going to sell it. And he had moved his family in, and he had taken care of mom on a daily basis, like intense caregiving. And the kids reacted in a negative way as a result. So I'm going to put in there reduce risk of family conflict or of legal contesting as a result, because you can put in there, you contest this thing, you're disinherited. You can put in your living trust very clearly who gets to manage it, since it's not a public record. They don't get to see all the numbers. So if you have, if there's kids, especially if they're disinherited, You don't want to invite that contest and bring them into court. You want to keep it outside of court, and you want to have there be a ramification if they start to rebel rouse. So you want to make sure that you have that. Number 6, and I mentioned it over here, that there was no estate tax benefit and that there could be, depending on what happens. When there's no portability, then there's the estate tax benefit. There can be a benefit when you have a living trust. If you don't have a living trust, you're toast. If you do, then it's possible to use up the spousal exclusion of what they're entitled to and put it into trust for the benefit of the survivor. As of right now, they changed the law to allow the portability between the spouses, but that wasn't always the case, and it could go back. So it avoids that happening. There's also different types of fees and certain types of taxes that could also be applied on the event that there is a probate. Some states have different types of costs and fees, and this will avoid, by using that living trust, you can avoid those expenses by using the living trust and opt out. So there are those benefits. Number 7, there is some asset protection. And I'm going to explain in a few different ways. Number 1, there's credit shelter provisions, so that if you have a beneficiary and they have a creditor, that creditor cannot force the distribution out of a trust. If they're in a will and they're entitled to they're entitled to the estate, you could step in and take it. A creditor could step in and take it. Not so with a living trust. So there's that type of asset protection. There's also protections for special needs. If you have beneficiaries that are receiving state assistance, then there's provisions in our trust documents and well-drafted living trusts, not just ours, but they'll put in provisions that say to the trustee, do not distribute any assets if it will cause the loss of a state benefit, or if they have special needs and it would cause them to lose some sort of state benefit or access to additional capital. So there is an asset protection component. Let's say that you have a beneficiary, they're going through a divorce. That's another one where this asset protection, hey, no distributions, the trustee's in control. They're directed to not distribute if it's going to go to a third party or if there's a judgment creditor or something out like that. Next, 7, I'm just going to call it blended families. And I'll say blended families and special circumstances, but if you just have a will and you have money go to the parent, this happened in my family, by the way, money just goes to grandpa or grandma or to whoever the beneficiary is, and then they get married. So, so here's the scenario. Mom and dad are married. Dad predeceases mom. Mom gets 100% of the estate. She gets remarried. She predeceases her new husband. That entire estate just moved to the new husband, and you disinherited your kids. That actually happens. Think about what's the famous case, Anna Nicole Smith. Remember the 28-year-old playmate who married I think he was 88 years old, the guy that was in the wheelchair, and the entire estate was going to her, right? The kids contested, they jumped up and down, fraud and everything else, but he had a wife who passed away. Here he is, he's got everything. When you have a blended family, you might want to make sure that your kids aren't disinherited because everything's going to the surviving spouse. So there are provisions in the trust that enable you to continue to stop that from happening so that it doesn't occur where you've disinherited somebody. All right, multi-state planning. I'm going to put that up here. So most of my clients are real estate investors, and they have properties in multiple states. If you have property in your name, in a state, and you pass away, you're having to probate it in that state. So you end up with multiple states where there's multiple probating. One of the ways around it is just to use a living trust. Now, we use land trusts and LLCs, but if all you did was put your properties into living trust and you just Your living trust does not have to be registered anywhere. There's no state filing fees or anything like that. There's no upkeep. There's no tax return until you passed away, and even then it may not. What will happen is by putting those properties into the trust, now you don't have to probate in each one of those jurisdictions. So let's say you have property in 3 jurisdictions. Hey, I got property in Nevada and Washington and Georgia, right? I don't want to have to probate in all 3 of those jurisdictions. Let's say you live in Nevada. Okay, if I have a living trust, I don't have to probate anywhere. If I don't, and I just do a will, I'm probating in Nevada, Washington, and Georgia. So we want to avoid that. This is another advantage, is by using the multi-state property. And then there's also an element, I'm just going to put this back up here rather than writing down. Run out of space. For married couples, there can be asset protection as well if you're using separate property. The trust can classify property in a specific way so that you do get benefits. Somebody passes away too, and there's future creditors that come on with that spouse, rather than having your assets. So if let's say spouse 1 passes away, spouse 2 survives, spouse 2 makes some bad decisions and gets into some legal trouble or has creditors, if you're doing it right with a living trust, and you're following good advice from counsel like we would do, chances are that the deceased spouse's estate trust is now sitting there separate for the benefit of the survivor, but there's credit shelter provisions in it so that nobody could go get it. So if you have kids and you want to make sure that they're going to get an inheritance, this is one of those ways, because the decedent, the spouse who passed away first, their estate can go into a trust for the benefit of the survivor, but not available to the creditors of the survivor. So there are additional benefits by using that living trust. So there we go. So I laid it out. I did the cons and I did the pros, so you can make an educated decision. But I wanted to be very clear and cover fairly the 7 disadvantages of putting your home into a living trust. And then we can contrast it with those advantages. Hopefully you got value out of this. Share it with anybody you want to, and like and subscribe, and I'll see you later.